I want to welcome everyone. I want you to know that when it comes to fair housing, it's the love, my passion, and it's about making sure that I empower others by sharing the information about the law. We're going to provide information to those who have disabilities, but it is very important that those of us uh, who are sitting here thinking, well, I don't have a disability, know that you are what we call a TAB, temporarily able-bodied person. So this information is important for you to know, for your family to know, so that you would know to do just in case there's a disability and you're dealing with housing issues. I do want to let you know that whatever I talk about today is about the law. I'm not able to give you legal advice. Whenever you need to have legal advice, you need to find someone that's not just an attorney, but an attorney with knowledge of fair housing. So, let's take a quick review about the Virginia Fair Housing Law. First of all, if you're asking yourself, why is it that we have April as Fair Housing Month? It's because everything that happened around fair housing happened in April. To start out, we had the leader of nonviolence protests for civil rights, Martin Luther King, being assassinated on April 4th, 1968. One of the things that he fought for was equality in housing, so that anyone who wanted to have housing would be able to do so without having to deal with discrimination. But 57 years later, we are still fighting discrimination in housing. He died on April 4th, 1968. A bill, the Fair Housing Bill, that was authored by two senators, Senator Brooke and Senator Mondale, sat in the Senate for 2 years until that assassination and the reaction of the African American community, which was anger and destruction of many of their communities. That got the attention of President Johnson, who then instructed the other legislative houses to go ahead and make a change that would send a message to the African American community that their leader did not die in vain. And that change became the Fair Housing Act of 1968. 4 years later, in 1972, the General Assembly enacted the Virginia Fair Housing Law. Virginia became the very first Southern state to have a fair housing law. And Virginia also became the very first state to partner with HUD to become a FAP, which is known as a Fair Housing Assistance Program, where the government of a state does the work of a HUD on a state level. So that's why we celebrate Fair Housing Month in April. When the law was enacted in 1968, there were only 4 protected classes because at that time, that was the discrimination taking place. When we deal with civil rights laws, they have to base their protection on occurring discrimination. So, in order to offer protection, we knew that people in the African American community, those who were descendants of Africans, were dealing with major discrimination. Segregation was encouraged to a certain point, racism was encouraged. So it kept people of color out of many communities. So they had a very big stake in getting this law passed.
Excuse me, Ms. Malley, to
Yes.
interrupt you. I just got the text that your presentation is not displayed. I just wanted to double check with attendees that if they can see the presentation slides. If you can just raise your hand or just unmute yourself.
Could you
I can
see
see
it?
it. I see it. She's on page 7 of 99. I see it.
Okay.
Thank you. Thank you.
All right. Thank you so much. I appreciate it. Sorry.
Appreciate you. That's okay. That's good that we stop. Maybe that person that can't see it may need to go out and come back in again, and that way they may be able to get it. All right. Yes. All right. So in 1968 we had 4 protected classes. That was race and color, for the protection of those in the African American communities and who were descendants of Africans. National origin, that covered your Mexicans, the Chinese, even the Native Americans, which was really shocking to me because they are the original people of this country. And it also covered religion, because one of the things that this country wanted is that anyone who wanted to be part of this country could enter regardless of whether they had a religion or not. Later on, the law was amended to add sex. That was in 1974, and that was a big help for women. If we look at the history of women and land, we know that women were not able to own land. Women were not able to make decisions about land. Women were not able to access housing unless they had a man with them. In 1988, President Reagan also participating in another amendment of the law where familial status and disability were both added to the law. Virginia, on the other hand, adopted the 7 protected classes of the Federal Fair Housing Act. That is one of the requirements in order to be a Fair Housing Assistance Program, or a FAP. You have to at least have the 7 protected federal classes. And then Virginia, like any other state, was allowed to add protected classes and even allow localities within the state to have their own fair housing law. So Virginia added in 1983 elderliness. In 2020 was a big amendment. They added 4 new protected classes. Those were source of funds, sexual orientation, gender identity, and veteran status. In 2021, they amended veteran status because it was quite limiting, and they broadened it by replacing veteran status with military status. So let's talk about the protected classes under the Fair Housing Law. The first thing we want to know is, what is a protected class? When I first started in 2003 with fair housing, that term kept popping up. So the term is one that is used under federal, state, and local laws. It's describing a group of people with common characteristics that, because of those characteristics, they're targeted for discrimination and harassment. So in Virginia, we have 12 protected classes. To recap, those protected classes are race, color, religion, national origin, sex, familial status, disability, elderliness, source of income, sexual orientation, gender identity, and military status. So when we look at race and color, a lot of times people think, oh my, what's the difference? There is a difference, folks. Race is about a construct that was created in the New World. It allowed for people of European descendants to have power over all others. When it comes to color, color is about the pigmentation of your skin. So within a family with the same mother and father, you could have one person that is just as light to almost white. And at the other end, you can have another person who is very, very dark skinned. They're all from the same family. The only difference is the pigmentation. In a lot of cases dealing with national origin, we would also have to include color, because many of those of national origin have a different pigmentation from those of European descent. So pigmentation should not be a reason for someone to deny someone else housing. When it comes to national origin, we're referring to people of other areas of the world that have migrated here. But it could also refer to many of those who are their descendants, that because of their appearance, they are also looked at as being national origin. In many of those cases, we talk about the Hispanic community. When you look at the Hispanic community and their descendants, oftentimes we sometimes feel like this person is Hispanic. I know they're probably not going to speak English, or they're not from here. But that may not be the situation. Many of our folks here are American citizens. Religion. Religion is about a choice. Some people are very fervent about their beliefs and their religious practices, while others may choose not to have a religion. That should not matter when it comes to housing, because every human being needs housing, regardless of what their religion may be. So in the case of religion, you have a choice of having a religion or not, but it should not affect your housing decision. When it comes to sex, that is an interesting protected class, because what we're looking at is, in many cases, people feeling that males have more power over females. Well, we've seen over the years that females are doing the same jobs, handling business, and in most cases, you would find that when there is separation within the family, mothers are usually the ones with the children. But they were very much affected for years until 1974, and there's still a certain amount of discrimination going on within the communities when it comes to sex. There is, we highlight things like sexual harassment that usually affects mostly females. But it's not to say that males don't go through it also. We are also looking at domestic violence. Housing providers cannot evict a domestic violence survivor just because of the behavior of a partner of theirs. And pregnancy. In so many cases, we had situations where pregnant women were denied from refinancing their homes or even purchasing a home during their pregnancy and maternity leave, because bankers said that women, after they have babies, will not go back to work. So they were requiring women to have 2 paychecks plus return to work before they would close on their homes. So here are the extra protections that go with it. Familial status and elderliness. I call those two the same age. I was tickled when my dad used to often say, once a man, twice a child. But I have to agree with him, because now, having grandchildren, I have the best excuse to tell my children that my grandchildren and I are the same age, and so we get to act up if we need to. So when it comes to familial status under the Fair Housing Law, it is the protection of families with children under the age of 18. So in this case, I have to remind housing providers often that children are residents too, and that the laws should the rules and the policies that they have on those properties must apply to everyone. So saying things like, hey, parents, if your children are outside, you have to be out there watching them 24/7, that's not true. If you have rules that are saying things like, we allow children to swim from maybe 10 a.m. till 4 p.m., but after 4 p.m., it is adult swimming, those things do not are not allowed under the fair housing law. So the rules and policies have to be across the board for everyone. And then we have our elderly community. In 1983, Virginia decided to protect the elderly. What they did was to make sure that we have elderly communities. There are two choices of elderly communities. There's the 55 and older, where every property is able to set their policy, and they could adopt the 80-20 policy, which means that 80% of the occupied unit has to be occupied by someone 55 and older, while the other 20% could be anyone else. It could be people with disabilities. That was a thing that was needed, especially for those with disabilities, before we established what was an accessibility requirement under the law. So what happened was, in many cases, people with disabilities weren't able to have accessible housing. The one place where there was accessible housing was within public housing. So in many of those public housings that are elderly, you would find that they also accept people with disabilities. And in some cases, they have accepted families with children, especially during the war in the Middle East, where many of the parents were deployed. And so grandparents had to stand in as those who were given the power of attorney to take care of those children. And in many of those cases, the residents in those communities understood, and children were allowed there. Source of funds was supposed to be the ultimate reason for families being able to have choices. For many years, things like the housing choice voucher, some property owners would discriminate against it and say, we don't accept housing choice vouchers. Well, that is not something they can do anymore. Any legitimate income is allowed to help those seeking housing and not able to, come up with the money for the housing. As we all know, housing is very expensive. Over the years, it has gotten more and more expensive. So for some families, it is harder to provide housing for their family. Therefore, the housing choice voucher and other income help is very important to these families. So there is an exemption. That exemption was voted on by the Virginia public. So we have it where if a person is an owner of 4 or less rentals, they are exempt from having to rent to someone with a housing voucher. Same would apply if they are 10% interest owners in an entity, or if they're unable to get the property approved within the 15 days that they're given to have that done, then they're exempt from the law. But I will tell you that Washington, D.C. had a major case a few years ago in which a property management company decided that they would not accept housing choice vouchers and found ways to get around it. But after an investigation, it resulted in them having a $10 million actual civil rights penalty for not working with people who had vouchers. Sexual orientation and gender identity was a journey. Oftentimes, within my 21 years and before the General Assembly actually amended the law to add sexual orientation and gender identity, I was often asked, Ms. Molly, when are they going to protect those of us in the LGBTQIA community, because we need housing too. So it doesn't matter what your sexual orientation is, whether you're heterosexual, homosexual, or bisexual, we all need housing. And therefore, that should not be a reason for someone to negate housing just because you are not of the perceived sexual orientation that they would like you to be. Same with gender identity. It all comes down to what I call respect. If I expect somebody to respect me, I'm going to have to respect them. And if they would like me to call them by a certain pronoun, then that is what I am going to do. Now, I will tell you, I've made my mistakes too, and have said he or she in the wrong places, or even for those who want to go by the they and them, I have messed up there. But I also ask them to please understand that this is also something that I'm getting used to, but it is in no way a form of disrespect to them. So, gender identity is about wanting to be the person you believe you are rather than what you were assigned as at birth. So, in some situations, you may have someone that comes to the property, and yes, their paperwork may be in one name, but they also would like you to know that they're, looking to change that. And yes, they would like to be spoken to by the chosen pronouns. Military status. For those who have sacrificed their lives for us, there should never have been an issue when it comes to housing. Let me just go back in a little history and let you know that for many of our soldiers of the past, housing had been denied. Many of the soldiers of color, though they were the major amounts and had the highest losses when it came to lives, they were also denied many of their rights. These soldiers were supposed to have been able to enjoy what we now know as the GI Bill. That GI Bill gave them benefits when it came to health, when it came to housing, and when it came to their education, all to get them back on their feet and get them going after serving this country and sacrificing their lives. Many have returned with disabilities, but they keep going because it's all about the country. So, for those militaries, we make sure that they know that they are protected. Not only that, their dependents are protected. At one point, we had a couple of our leaders in Congress discuss the possibility of retroactively giving those soldiers what they deserved and were not able to have many years ago. And some of them are not around to get it, but what they have said is that in denying housing of these military persons, they also denied their families from generational wealth. And we know that one way to definitely have generational wealth is through land and housing. So today's training, we are focusing on the rights and responsibilities of people with disabilities and the Virginia Fair Housing Law. So the first thing we want to do is to define disability. We know that it is the most misunderstood of the protected classes. It is also the number one in complaints nationwide, accounting for 52.6% of the complaints. So what is a disability? And of course, you see that I put a child there so that we all will be reminded children are also protected under this law. So when it comes to disability, we're talking about a physical or mental impairment, but not just having that physical and mental impairment, it has to affect one or more major life activities. So it's not just like I had a call a few years ago, and the lady says, my daughter has asthma. She has a disability. And the doctor will not give me a note to that she has a disability. And I said, well, what would you like me to do, ma'am? And she said, I don't know, but my daughter has a disability. What this lady didn't understand is that just having asthma does not make it a disability. Now, if that asthma compounded and became a COPD, that's a whole different ballgame because, of course, you're going to be affecting one or more major life activity. In this case, it would be breathing, because as we have seen over the years, you have people walking around with oxygen. More than likely, there's a COPD diagnosis there. So you have to have the condition, but that condition also has to affect one or more major life activities. Like if you had diabetes and you lost your eyesight, you have a disability. You, the second definition says you have to have a history. In this case, we could talk about cancer and remission. There was the Sony case from a while back where there was a lawsuit because a young lady had cancer, went into remission, and Sony felt like she didn't have cancer anymore. But we know that remission means that there's a possibility that this cancer can return. So in this case, that person won their lawsuit even though they had passed at the time. They won their lawsuit and the family was able to get justice for them. So having a history of such an impairment is also important. My favorite one of the definition is being perceived by others as having such an impairment. So you may see someone that has um, some type of rash or poison ivy or whatever now this time of the year, and you're assuming that, oh my gosh, they must have an infectious disease. I'm not going to get close to them. Look out now. You're telling everyone in the building, oh, look out, don't talk to Mr. So-and-so. His hands look funny, that whatever he has, who knows what it is, it may come out on you. In cases like this, if the person feels that they have been discriminated against, if they feel that they are being harassed because of this, even though they don't have a disability, because they were perceived as having one, they have every right to file a fair housing complaint against those who have been harassing and discriminating against them. We need to speak up. There are times when disabilities are not visible. That doesn't mean they do not exist. I see so many of the videos, especially when it comes to parking spaces, and people assuming that because a person comes out of their car and is able to walk to the store from where they were parked, that they are fine. That is not something that especially housing providers need to do. Never assume. Always go with the facts and know that we have so many diseases. Lupus is one, MS is another. You know, people are not showing symptoms of it, but they have the disability, and those flare-ups are intense in many cases. So, inspired by Sahar and doing this training for about 3 or 4 times now, I came up with having that superhero image. And housing providers can have equality if they follow what this wonderful fair housing equalizer says, because he's here to talk on behalf of those who are with disability. So one of the things that I found when I got involved in fair housing is that in many cases, housing providers told their staff to treat everyone exactly the same. I would tell you right now that if you are a housing provider here today, please stop telling that to your staff, because ultimately they're going to discriminate against those with disabilities. I was giving a class in Virginia Beach one year, and I was talking about, what the wonderful superhero tells us. You see, under the fair housing law, it is essential, it is a priority that everyone has equal opportunity to use their homes, public and common use spaces, and all the amenities on that property, just as an able-bodied person would do so. In order for that to happen, fair housing has established two processes that a person can ask for if they have a disability. One of those is a reasonable accommodation. The other one is a reasonable modification. So, what about these two? Okay, so when it comes to a reasonable accommodation, we're talking about an adjustment, a change, an exception to any rule, any policy, any practice, or any service. If that change is going to allow the person with the disability to enjoy their home, the property, and all of the amenities. So, examples of reasonable accommodations. Parking spaces. A person with a disability, having mobility issues, having breathing issues, maybe, they're an amputee, that is very visible. They can request a personalized parking space. That parking space will be marked for that person to use and that person only. So housing providers, when they line that parking space up, they also need to put some type of signage that says this parking space is reserved for resident with ID XYZ. You don't want to use their names. You don't want to use their unit number, because that comes under the none your rule. Nobody's business. Okay, none your business. Exactly. So, what if the person lives on, let's say, in a house that is on the side of a road? How would they get a personalized parking space? In that case, you would either have to go to the county or the city where you live, and the housing provider would ask that the county or city set up that parking space for the person with the disability. So that's one of the things that you would have to do. You also want to remind your other residents that that parking space is not theirs, and they will be told if they use it, because that space is reserved for the person that requested it. Assistance, companion, emotional support animals. Oh, these are like the ones that get most of the attention when it comes to reasonable accommodations. Many have realized that if you have a disability and there's a need for an animal, that you can request one, even if the property has a no pets policy. because in this case, these animals will not be pets. They will not be a want. They are a need, which makes it different and, makes a big difference. So, one of the things I need to say is when it comes to service animals, that is under the ADA. Under fair housing, it is assistance, companion, and emotional support animals. Now, ADA only limits their service animals to dogs and miniature horses. That's it. I still think that they need to add the monkeys to that because the monkeys become hands and feet for many of those who lost the abilities to use their hands and get around on their feet. Under the assistance, emotional support, and companion animals, they can be any animals with justification. I remember when Chair Randall came to do the proclamation at the fair housing event that we had this Monday, she recounted a case in which a person had a boa constrictor and they wanted to have this animal accepted as their assistance animal. It is the same as the gentleman who went into Burger King also with a boa constrictor and said it was um, he said it was his service animal. And of course, ADA said no. In that case, no. And so did Chair Randall and the Virginia Fair Housing Board. They also had to say no. But we have dogs, cats, rabbits, ferrets. There are so many different animals that are part of this group that actually help people. And in some cases, we may not understand, but as a grandmother now of a child with autism who is nonverbal, I said it before and I will say it again. If my baby boy went to a farm and he saw a duck and that duck quacked and it made him talk, that duck is going home with us because my baby is going to keep talking. So it is sad that sometimes we have to have people get into a situation to understand, but I have met many who have emotional support animals, especially some of our soldiers with PTSD, and these animals have made a difference for them. Living aids. Living aids are an extension of the person with the disability. The things that they can't do is what the living aid is going to do. The living aid is not a resident of the property. The living aid is there as it would be a wheelchair or an assistance animal. Therefore, they do not have to be screened. Now, if there's something that comes up, you can address that with the person, but the living aid is not screened. The person that is screened is your resident, and that's the person with the disability that needs the living aid. In some cases, we may also need to have an extra bedroom if that living aid is going to be staying there 24/7. So that extra bedroom would not be an additional cost to the resident. It will be a reasonable accommodation for the resident to have their living aid with them. For many of those receiving SSI, SSDI, one of the things that we know is that they do not receive those checks the first of the month. They can come at different times depending on your birth date. So it is at times, I will let you know that many of those who have disabilities have no idea that they can make these changes. But if the housing provider sees that a person with disability is constantly late on their rent, they may want to offer them that change and say, we can change it to coincide with when you receive your SSR, SSDI. Now, if you're late after that, then you have to deal with the consequences. But as long as you are within the 5 days of that due date, then you should be fine. in going to meetings, in having communication shared to all your residents. Housing providers need to make sure that everyone is getting the same communication. So at times when you have your meetings, you may have to have someone there to do the sign language. Or if you don't have sign language, a way in which they can stay, up to date with what is being discussed. It could be we were able to use a court reporter, and she actually did the translation that would show up on the TV and in typing, and so the person with the disability could read what was happening. So these are some of the ways that reasonable accommodations are valuable to people with disabilities. The request that is made can be made either way. And housing providers need to understand that not everyone is going to walk into their office and say, hey, excuse me, I need a reasonable accommodation. I will tell you right now that if you are a housing provider sitting here listening to me, that you understand that if someone walks into your office and say, I would like to have a reasonable accommodation, you better dot your I's and cross those T's, because that person knows exactly what they're asking about and what they're talking about. So if you falter in any way, there might be consequences that you may have to face, including an investigation about why you negated them. So I would also say to those who are requesting reasonable accommodations that you do it in writing. You always want to have a paper trail. You not only want to do it in writing, you want to make sure that you document the name of the person you handed that reasonable accommodation request to. And it doesn't have to be perfectly written. This is not about school. This is about people needing help and needing assistance in getting what is in their right to obtain. The resident has to have a disability as described under the ADA. The request that is being made has to be related to the disability. And, I at one point, you're looking at the possibility of a resident who is blind asking you for a parking space. Don't be shocked. They have the right to have a parking space just like anyone else, because if someone is coming to pick them up, that person needs to be able to park in a place that is accessible to that person with the disability. So it may not be for the resident that is blind to park in, but whomever is assisting them is able to park there, and they have the right to that. When it comes to who pays for reasonable accommodation, the courts have all agreed that the housing providers are the responsible ones. So going back to that young lady in that class in Virginia Beach, she said to me, oh, Miss Molly, I have a resident that is getting a hip replacement, and she wants to move to the first floor apartment, but she hasn't given us any verification. And I said, ma'am, if she's having a hip replacement, that's enough verification for you right there. And it so happened that this lady was not able to schedule her hip replacement because she lived on the third floor and would not have been able to negotiate the stairs going up. She's having a problem negotiating them she was talking to me about it, because the hip needed to be replaced. So in a case like that, please, if you know that the person has asked for that first floor unit and there's a reason for it, then it needs to happen. A big surprise came in 2013, but it wasn't a surprise to me. I watched an episode of Hoarding. It was about a gentleman who lost his wife, and the loneliness made him turn to rats. He adopted 3 rats, 2 males and a female. By the time the people came into his home to round up these rats, this gentleman had no electricity because the rats had eaten up all the wiring. He could not sleep in his own bed, that when you raised the mattress, it looked like confetti falling out. He had to sleep in his office or shed across from the house because they were gnawing at the top of his head. What made me realize that hoarding was a mental disability is when that gentleman cried, literally boo-hooed, because one of the rats was found dead, and he apologized to the rat for allowing him to die, for, well, not allowing, but causing him to die. I don't know why he felt like that, but again, it's part of what he was dealing with. Hoarding is about trauma, some trauma that caused a person to hold on to things, even though they may not make sense to them, they are valuable. And the accumulation of these things is unhealthy. There is no real, what you would say, organization. They just get things, and it's all over the place. Most people think that having a lot of stuff is the hoarding, but it's not. It is not being able to get rid of things. That's when it becomes hoarding. 6% of the world's population hoard. More than likely, your hoarders are going to be females, elderly females. And what I tell people is that the scariest thing that a hoarder can say to you is, don't worry, baby, when I die, all of this is yours. Most families are like, no, we can't, don't need it. What is a reasonable modification? When it comes to reasonable modifications, it's about structural or physical changes to the units, public or common use areas. Here, we're looking at this really fancy house. And this is one of my dreams, y'all. And I don't think that, as far as I'm concerned, I don't have to have a disability, but it would be there also if I have one. So in this case, the person put a lift in their home or an elevator. There are homes being built now where they leave that, it looks like a closet, but it's actually a space where you can install an elevator. And some people have. That elevator would allow you to still enjoy your home that is 2 or 3 levels and be able to use it and enjoy it. So when it comes to examples of modifications, it could be lifts. Lifts are what you would put at stairs. So I remind housing provider that not everyone in a wheelchair wants to live on the first floor and have over other people over top of their heads. Sometimes they would like to be able to do the same. So whenever your housing providers are showing housing, they should show whatever they have available, even if you may think that that person is going to look at you like you're crazy. What you are doing is showing them that you look at them as an equal. So you may get to a building and say, we can go see this building, but we do have stairs. Would you still like to take a look at it? So it's up to the person to say yes or no. Ramps, when it comes to ramps, some areas, one of the things that I talked about Monday at our event is that when it came to HOAs, I was not a big fan of HOAs because I don't feel like for such a huge investment, financial investment, that someone should tell me how, where, and why I should do certain things to my home. So ramps, in some cases, people are told that it robs from the aesthetics of the community. My question to them is, do you really think that a person paying all that mortgage really cares about what the aesthetics is if they can't get into their own home? And a ramp may be needed at any time. It could be a child, it could be a grown person. So, in the case of ramps, these are necessary. There are times when housing providers would say things, well, I don't want it at the front of the house, I want it at the back of the house. So if you want to put a ramp in, you put it in the back so that no one has to see that there's a ramp. Wow. To that person with the disability, that's not a good feeling at all. So really think about how you answer these requests before you answer them. Grab bars, they are essential in the bathrooms. My late husband had a stroke. Boy, those grab bars are coming in handy even now that he's gone, because some days it's hard to get up off that throne and get on my feet. So grab bars are essential. They help many to get around, to get up, get down, and enjoy using the bathroom as anyone else. Widening doors. Doors should always be at least 32 inches wide. That is the standard for people who are in wheelchairs, but many goes beyond that and go to the 36 inches wide. So if someone moves into a home and those homes were probably built years ago where the doors are very narrow, the person with the disability could ask that they are allowed to widen the doors so that they can get in and out through them. Installing lever doors. As I get older, my hands hurt a lot more. It's from years of cake decorating and catering. And so a lever door where the handle, you just have to press down on it. I even say when your hands are full, if you're like me that doesn't like to make a whole lot of trips back and forth to the car when you're bringing in groceries, you can hit that little lever handle and get right into the house with no problems. Removing carpet. Some, uh, especially those who are having issues with their lungs, at times they may need to remove the carpet. We knew one gentleman that also was in his wheelchair, and the wheelchair, it was hard to get around in the wheelchair on carpeting. So he asked that they remove the carpet so that he could put flooring in. And in many of these cases with modifications, I have to say that to me, there's an improvement. And not only that, but there's an ability to then market that unit as a unit for people with disabilities. And it would be quite a welcome news for many. So, more details about modifications. Just like with reasonable accommodations, you have to have a disability. The request has to be related to the disability. The housing provider has to allow that request. The resident is the one that is financially responsible for that request. So that's a huge difference between reasonable accommodations and reasonable modifications. Also, reasonable modifications are really geared to those properties that are not federally funded. So on federally funded properties, any change that is made, it will be considered a reasonable accommodation. So Loudoun doesn't have public housing, but in public housing settings like in Richmond area that I'm close to, when that public housing makes any changes, it is considered a reasonable accommodation. So there's no money exchange. When it is a property that is a regular property or a self-funded property, that property requires the resident to make the modification when they have given them the permission. That property can also look into whether that person that the resident has chosen to do the job is a licensed contractor. You definitely want to always work with someone that is a licensed contractor. Why do I say this? If there are any problems, you have a go-to, and that go-to is the Department of Professional and Occupational Regulation, where they regulate those who are contractors. So if there's something that happens, you can complain to them and get justice. If you use someone that is not licensed, then you would have to go through civil court, and that could take a while. DPOR has what is called the Victims Fund, and from there, they are able to get some justice for that person who has had a bad experience with that contractor. For those who are having maybe a hard time getting that modification done, there are certain organizations that you can turn to for help. I believe HUD has a list of those, but for like those who are veterans, you have this, organizations related to the VA, like Ramp America. Those guys will come out and build ramps up. You have Habitat for Humanity, different organizations that you can go to and ask for assistance. The housing provider may ask that resident to restore the property back to its original state. But let me just say that it needs to make sense, because in the case of widening a door, why would you widen the door and then expect the housing provider to then narrow the door back to where it was? So it needs to make sense. In the case of a person needing a vanity to be raised up so that them in their wheelchair could use that vanity, then if the next person using the unit does not need that vanity where it has been modified to, then that would have to be restored. And in that case, housing providers can set what is called an escrow account, in which the resident can make monthly deposits or timely deposits into the account to offset the cost of restoring the modification back to what it was. So audience, do you think there are any other concerns that people with disabilities may have? Hit the chat and let me know if you could think of any other concern for people with disabilities. This is your opportunity to participate.
Please put it in Q&A box. The chat box is not active.
Oh, okay. In the Q&A box, yes. So do you think that I have missed out on anything that people with disabilities need to know about? Don't be shy. We're all here to learn. Did we get any answers?
No.
No? Okay, they're shy. Okay, so let me give it to you. Yes, we did miss, and it's group homes. Now, group homes get a lot of conversation going, especially in the beginning when people realized that group homes were protected and you could not allow them to come into your communities. So if you haven't heard about the Olmstead Act, that was the driving force behind group homes. What they found is that many of the people that we call people with disabilities could very well function in our communities. We isolated them for years. We put them in institutions. Some people even left their children there and forgot. In traveling the state, one of the beautiful things that I've been able to experience are those stories from real life people. And I remember meeting a couple, and that couple was talking about a young lady that was in an institution for years that didn't know her brothers because her brothers didn't know she existed. Their mother was pregnant. She had a child. But when she came home, she had no babies with her. And when she was asked, they were told that the baby died. Well, years and years later, mom and dad pass, and they find this trail that is going to a group home. And that trail led them to their sister. Of the three brothers, I believe only one of them was interested in meeting her, and he went. But that couple were the ones that took her in, along with some other ladies, into their group homes. It so happened that the wife was worked with people with disabilities. She did not like how many were treated, even in some of the homes. So she decided to have her own group home. And this young lady came from a pretty famous background. And unfortunately, no one knew she existed. I did see her. She was part of um, I guess, a little documentary that was done by one of our news networks. And she was so happy and thought her room was so beautiful. And now she had a whole family to herself. So in 1999, the Olmstead Act was enacted, and thus came group homes. And a group home is where unrelated people that need care, support, supervision can live together as a family. Um, Most times you will find that it's the elderly or those who may be mentally ill. But in all, these group homes are considered a single family home, even though they may have up to 8 persons that are unrelated living in the home. We have group homes all over Virginia. In fact, at the end of my cul-de-sac is a group home. And I shared with the audience on Monday that when the group home came to my neighborhood, one of the teachers in the schools there in Chesterfield approached my late husband, who was one of the workers at the YMCA part-time so that he could get use of the gym all the time. And she came in and she was quite interested in talking about the group home in our neighborhood. She wanted to know if my husband was upset because this group home came in and no one knew they were coming. And my husband pointed out to them then that no one knew that he and our family were coming to the neighborhood either. No one announced it. And then she said, and you know, according to them, they have disabilities. Have they told you what type of disabilities they have? And he said, no one asked me or my wife or children if we had disabilities when we moved here. I guess she then realized and said, oh my goodness, you know, I guess I should shut up, huh? And I said to my husband, what did you do, baby? He said, I just smiled. And that was enough to let her know, yes, stop talking about it that way. In another case, we had a homeowners association that forgot that when you have meetings, people take minutes, and that there are reporters at time at the meetings, and they were discussing about having a group home coming into that neighborhood. People were asking questions were like, what if they got out and killed somebody? And it just shocked me. But because of that reporter, who then forwarded all the information to the Fair Housing Board, that case settled for just about the amount of money that that house cost. So that HOA was sued and had to pay, I believe it was like $342,000. In Crownwell, Connecticut, this case really blew my mind because it was a $5.2 million settlement in damages. I have spoken very much about Relman and Colfax. Relman and Colfax are an attorney's office that focuses on civil rights, and they are recognized for winning many cases based on civil rights. They took this case on and received $181,000 in compensatory damages and $5 million in punitive damages, which means that whomever is the person that owns these group homes will be able to put a lot more group homes around Cromwell. And let me just say that in the case of group homes, there can't be a steering going on. If you don't know what steering is, it means that if there's a city that has group homes and that's the only city you want to send group homes to, that is steering, because group homes should have a choice of wherever they want to be located. And if there is available property, they should be able to purchase that property. So let's talk about some more details under the law. We have exemptions, and exemptions only means that these folks that I'm going to mention are not regulated under the law. So you have your 3 single-family homes or less owners that can rent and sell to whomever they choose to without regulation. Also, owner-occupied buildings of 4 units or less. The owner, it says owner-occupied because the owner has to physically live there. So let's say you have a duplex. The owner lives in 1 unit and the resident is in the other, then that is exempt from the law. Single-family homes rented or sold can be done so without regulation as long as a real estate agent or broker is not hired. If you hired either one of those, they have to disclose all the time that they are regulated under the law. Religious and exclusive organizations are also not regulated as long as they follow the law when it comes to all the other protected classes. So a Muslim that may be of Asian descent has to be allowed just as a Muslim that is of an American descent. Schools and dorms, those two are regulated under the law. The best case scenario that I can give it as an example is the young lady going to school and notifying the housing department ahead of time that she had a service animal. The head of housing at the school told her she couldn't bring the animal to school. She said, "I need this animal." When you look into why the animal was needed, it was because she dealt with anxiety attacks. And this miniature Doberman Pinscher was able to at least sense when she's going to have an anxiety attack and get her to calm down. He would stare at her and she would calm down. That case became a complaint. And in that complaint, the school settled, not judgment, but settled for $140,000. As I said on Monday, can we say free schooling? Yes, it was. Elderly communities, as we know, are exempt from renting to families with children. Now, let me just tell you that there is a way that though these folks are exempt, they can get in trouble. And that is by advertising, whether orally or in writing, and stating something that is discriminatory. Example, for years, I thought it was okay for someone to say, this house is great for two people, even though there might be 5 bedrooms in there. Let me just say that is discriminatory. So if a person publishes something like that, it is saying that they don't want families with children there. Another example, so many of these elderly communities like to boast that they are an active elderly community. That word active can get you in trouble, because what if a person with a disability shows up? You cannot deny them housing. So when I see ads like that, those ads, you need to call the attention. In some cases at the office in Depot, we'll usually get with the newspaper and get something started that could result in some good advertisement when it comes to fair housing. Oh, I also want to say that when it comes to exemptions, one of the things that I always mention is that in 1866, a year after the Emancipation Proclamation, we had a law that actually addresses discrimination in housing. And that's the Civil Rights Act of 1866, where it states that it prohibited discrimination based on race or color. There are no exemptions there. Someone asked me, why is it those words weren't powerful enough? Well, when you have a society that was ingrained with separatism, segregation, racism, then when the majority went along with that and they had power, it caused that those words in that law to be irrelevant. So then you had to have the fair housing law, which today is also being threatened. Other actions prohibited under the fair housing law: harassment. When it comes to harassment, there's no way that you can be able to enjoy and use your home and the property and all the amendments if you're being harassed. One of the things that the law says is that property owners and managers, if you are aware that this harassment is taking place, then you need to do something about it. If you don't do something about it, you are just as culpable as the person that is actually doing the harassing or the discriminating. So it is very important that you have policies, that housing providers have policies that address harassment in housing. Retaliation under the law, what they look at is a person being intimidated because they are engaging in activities that is making someone else aware of their rights and responsibilities under the fair housing law and encouraging them to exercise those rights. So if someone files a complaint and all of a sudden now the housing provider is nitpicking at everything that they do, that may be seen as retaliation. But there's another side to it also. It also covers those employees or agents that are being fired or quieted because they have assisted others to use those rights and responsibilities. One example of that was a case in, I believe it was Arkansas or Kansas, one of those two. But the housing provider tried to assist some Hispanic residents with knowledge of their rights and responsibilities under the law. That person was fired, but there was a complaint, and that person became part of that complaint that resulted in a $51,000 settlement between the plaintiffs and the responders. Restricted covenants. Restricted covenants is it puts limits on conveyance, on incumbrance, on rental, occupancy, real estate properties, and it's based on the protected classes. So for years, we had deeds that would say this house cannot be sold to someone that is not of the white race. In 1948, Miss Shelley went to court to fight one of those restrictive covenants and won. It didn't stop the restrictive covenants, but if you use one of those types of covenants today, whether it be with the HOA or it was something that was in a deed long time ago, you may have to face some fair housing action against you. So one of the cases that I can remember is my very first one, like in 2004, listening into the investigation and watching it go through the course of the courts. There was this gentleman in Chesterfield County that said that his deed said that he could not rent or sell his home to any Blacks, Mexicans, or Chinese. He then stated very powerfully that he was willing to rent to Mexicans or Chinese, but not to Blacks. And if they wanted to get housing, there was another gentleman just right up the road that they could go to, and because he rented to Black people and sold his houses to Black people. Yes, folks, that's what was said. They went to court, and I believe he paid something like about $14,000-15,000. He didn't lose the house, but he did. Even though this gentleman went to court, even though he had the verdict from the judge, who was very nice to him because it could have been worse, he still insisted that his covenant said that. But it didn't, folks. It didn't at all. He also stated that he could not read or write, but he was really not shy about stating that he knew that that's what was said in the deed. Criminal records and housing. In 2016, a policy was made, and that policy states that landlords and employers could no longer use blanket prohibition against people with criminal records. This was based on what we know as disparate impact. Disparate impact happens when you have a rule, policy, service, practice that seems by face to be neutral, but when you put it in practice, it has a disproportionate impact on one or more protected groups. In this case of criminal history, it comes down to the disproportionate impact it has on African American and Hispanic men. We know that the justice isn't that just at times. And in many cases, those who are innocent have been put in prison, and it took years, sometimes decades. One example was the young man that was accused of killing his own mother, only to find that DNA absorbed him from all that. But folks, he spent 3 decades in prison and was almost executed for something that he did not do. This is one of many, many stories. We also know that when folks come out of prison and they want to get back with their families, it is hard when you have policies that keeps them out. But on the other hand, we also have those success stories where many have come out of prison, turned their lives around, and are now doing awesome stuff for the society and helping others to make that change and do better. When we do not offer housing to people who may have had an encounter with criminal activity, what we're doing is setting them up to go back and reoffend. So based on one of the researches, there was one, I remember like about 5 years ago, up in Maryland, I believe it was, there was a little glitch in some of the convictions of some of the people there. So they were let out of prison under parole, the parole system. One of those gentlemen had everyone laughing because he said one of the things he had to learn was to use these newfangled bathrooms where he didn't have to flush. So for the first time he got out of prison and he was in public and he used one of those bathrooms that is a self-flushing bathroom, he didn't leave the stall because he was afraid that he was going to leave a mess back there. Anywho, that was one of his first encounters with the modern world. But he also said having a job and having housing was great because he had to think twice about where he just came from and not wanting to go back there any at all. So, folks, giving these people an opportunity, you look at what they've done, how long ago they did it. Was it something that is related to housing that would deny them from having housing? Things like that. It's a case by case situation. You don't clump everyone together. So case by case. And I believe they go back 5 years, no more than 5 years. So the other industries that are regulated under fair housing are advertising. And as I stated before, when it comes to advertising, you have to be very careful because what we think is just not an issue may be. So if you can't say it out loud, you don't want to put it in writing. But please also understand that there are situations where sometimes people are a little hesitant because they would say, okay, we have a nice walking trail. Well, that's not an issue if you say you have a nice walking trail because people in wheelchairs are walking just that they walk in their wheelchair. So it doesn't mean you don't have to say, walking, rolling wheelchair, walking, rolling path. It's just a walking path, and that's fine. Master bedroom. Some people wanted to take that and make it a slavery issue. No, master bedroom just means it's the biggest bedroom in the house. So things like that, sometimes we get to the point where we nitpick. But if it makes sense, it makes sense. Appraisers. What they're finding is that in some of the appraising actions taken, people of color are not getting their properties appraised unless they do what is called whitewashing. What do I mean by that? Some of the folks who have spoken up and have cases in fair housing have talked about having their home appraised with the way they had it decorated and found that the appraisal came out so low that they were not accepting of it. So they would get in touch with a friend who so happens to be white and take everything down that makes that home appear to be the home of a person of color and replace it with the white pictures and the white person in person. What they found is that in doing so, those appraisals doubled and even sometimes tripled in some cases. So I went to a conference and was enlightened by the fact that appraisers have a majority white appraisers. That leaves is like 96%, which leaves only 4% for the others. It is also a profession that requires you to have 1,500 hours in book instructions and 1,500 hours shadowing a seasoned appraiser. So if the business is 96% white, how feasible would it be to believe that we will diversify it anymore if you have to be an apprentice to another appraiser? So I believe that the housing groups and organizations are working on that because so many are losing lots of money when it comes to the appraisals of their homes. Construction and accessibility. If you are a person with a disability and you get to a property and that property has no way for you and your wheelchair to access and get around, that property has just told you that you are not welcomed there. This only points to those properties that were built after March 13th, 1991 for first occupancy. Those properties have to have routes into and around the property. They have to have accessible entrances. They also have to have accessible kitchens and bathrooms, which means that a person using the kitchen should be able to make a complete circle and use everything in that kitchen. If they are using the bathroom, they should be able to close the door and use everything in that bathroom. If these are things that they are not being able to do, then they have every right to complain. Those who have lived up to the standard of accessibility tells that if they have elevators in the building, every single floor is accessible and every unit is accessible. If they don't have elevators in the building, then all the ground floor units are accessible. Those ground floor units are important to have because at some point, someone in the property will need it because disability doesn't tell you when it's going to happen. Therefore, if you move someone without a disability into a unit that is an accessible unit on that ground floor, please let them know through an addendum that if you need that unit and there are others available, that they may have to move out of that accessible unit to allow someone with the disability to have it. Homeowners and renters insurance. There was a huge case in Richmond. Tim Kaine, our senator, was one of those involved in it. A young lady by the name of Rhonda Harmon was the attorney. I tell the story that they filed this lawsuit against Nationwide because Nationwide decided not to provide policies for African American homeowners in the Richmond areas, even though they were providing policies for white homeowners with the same type housing in the same localities. So seeing this, they gave the case to our Senator Tim Kaine, who then was one of the young lawyers in the office. And I guess the older lawyers thought that, oh, they're going to give the young buck this work to do and let's see what he could do. Boy, did he do a job. Between him and Ms. Harmon, who was at the time pregnant, she was put in bed rest. And I tell folks that sometimes in doing investigations, you have to ask for documentation. And when you ask the respondents for documentations, there are times where they play that game on you and just load you up with a whole bunch of documents, some that you need and some that you don't need, but it takes time to go through. Well, at the time, Ms. Harmon, who is now passed, was on strict bed rest and had all the time in the world to go through this document dump, finding a lot more than they expected to find. And in doing so, when the case went to the jury had a judgment of $125 million for that case and for housing opportunities made equal of Richmond. In the meantime, seeing this case happening also encouraged other major cities to file complaints against Nationwide, causing that $125 million to be split up, giving housing opportunities made equal about 17 $1.5 million, and other large cities like Los Angeles, New York, Atlanta, Chicago, etc., a cut of that money. So as you can see, they were dealing with redlining. And when it comes to redlining, you would have green area, it would be a map. They would use green lines to show those areas that are good to go when it comes to business. And they are mostly white areas. They have the blue areas where you have the blue collared white people living. You'll have your yellow areas where you have the what they would call some of the people who are kind of undesirable, and then you'll have your red line areas that they call undesirables. And who is in that area? The African American community. So for years, they were denied the opportunity to become, to get generational wealth through land. Mortgage banking does the same thing. So redlining is very, very much pronounced there. And redlining began back in 1930s. And in some cases today, we see a change because we're now dealing with gentrification. And gentrification was looked upon as something positive, but over the years, as we see, one of the things gentrification is also doing is moving people that were living in those communities for decades out of those communities because they can no longer afford them. So under the Fair Housing Law, if you or a family member has experienced any type of discrimination, and sometimes you may not be sure, something happened, you decided, you know what, let me make a few calls or talk to some people to find out if I am looking at something that is really happening and I'm not imagining this. Please ask questions. You have a statute of limitation. You have 1 year to talk to HUD or DPOR at the Virginia Fair Housing Office. That 1 year, if they accept your complaint, what they're going to do is investigate it along with conciliating it. What does that mean? While an investigator is asking the questions, we have a whole different department at in Richmond that would sit down with both parties if they agree to, and to see if they can come to a settlement. If they come to a settlement, then we no longer need to continue with the investigation. But if they don't, we have to continue with the investigation until the final investigative report is turned into either the Fair Housing Board and or the Real Estate Board. They are the ones that would decide whether this case goes forward as a cause case, meaning that there is some semblance of discrimination taking place, or if it's a no cause case. If it is a cause case, it goes to the AG's office, and the AG's office is the one that would then take it forward through the courts if necessary. But they too can conciliate the case, which means they too can sit with both parties and come to an agreement. If that first year passes, then there is still another year that you can file your complaints, but it would have to go through civil courts, and you would have to have an attorney unless you're able to fight your case on your own. In that case, there may be an exchange of money. With HUD and with Virginia Fair Housing Office, everything is done pro bono. More details? When you are filing a complaint, details are very important. Oftentimes, someone would say, oh, I felt I was discriminated against. And why do you feel that, I would ask? Oh, because I have a disability. Well, that's not enough. You have to let us, let in your reporting of this, details. I went to property XYZ. I met with this person on that day. I asked for, availability. I was told, and you proceed. Give dates and times. Who did you speak to? What actually happened that made you feel that you were discriminated against? Do you have examples that they are doing the exact same thing you're asking for others, but they're not doing it for you? These are important details. Keep copies of everything that you submit in writing. If you requested your reasonable accommodation in writing, have a copy of that. And, so that it is an example of the steps you have taken. Very important also, there are some people that are not comfortable speaking up for themselves. So they may have an advocate, or they may not be in the physical condition to do so. It is very important that you give permission to that person to speak on your behalf in writing so that it can be part of the file. And, the person that you have assigned would be the ones to get the calls and to keep you abreast of what's going on.